This is part 2 of contracts. We are beginning with termination of the offer by rejection by the offeree. This is where the offeree conveys an intent not to accept the offer. This is effective upon receipt. A counteroffer by the offeree is both a rejection and a new offer. An exception to this is where the offeree is an option holder. During the option period, the offeree has the right to make counteroffers. Acceptance by the offeree must know of the offer, must communicate acceptance to the offeror. In the unilateral contract, notice is required only if the offeree has a reason to know that the offeror would not learn of the requested performance with reasonable certainty and or promptness. In a bilateral contract, notice is always required. Method of acceptance of a bilateral contract. Acceptance can be made in a bilateral contract with either return promise or by starting performance. Commencement of performance in a bilateral contract operates as a promise to render complete performance, and as stated earlier, notice in a bilateral contract. Notice of acceptance of a bilateral contract is required. Acceptance of a unilateral contract. Promise to perform is insufficient for acceptance. You must perform the act, and this requires complete performance. Partial and or starting performance will allow a reasonable time for completion of the performance in a unilateral contract. As stated earlier, notice of acceptance is required in a unilateral contract where the offeror would not learn of the performance with reasonable certainty and or promptness. Acceptance in the context of an offer to buy goods for immediate shipment. That's where the purchaser offers to buy goods for immediate shipment. This is a request that goods be shipped by the seller. An acceptance of this offer is by a promise to ship, by the seller's promise to ship and or prompt shipment of conforming and or non-conforming goods. Where the goods are non-conforming, this is both the seller has both accepted the offer and breached the contract, unless the seller seasonably notifies the buyer of non-conformity. Then the goods are tendered as an accommodation and no acceptance has occurred, and the accommodation is deemed a counteroffer. The buyer may then either accept or reject the accommodation. The mailbox rule. The mailbox rule is where acceptance mailed within the allotted time for response is effective upon posting. It must be properly addressed and include correct postage. On the exam, the mailbox rule applies only to acceptance. A rejection is effective at receipt. Where a rejection follows an acceptance under the mailbox rule, so you mail an acceptance, then you mail a rejection. The latter sent rejection is generally ineffective. Again, a rejection is effective upon receipt, where acceptance is effective upon posting. You posted the acceptance prior to mailing the rejection, acceptance is effective. However, there is an exception. This is where the rejection is effective, where the rejection is received first and the offeror has detrimentally relied on the rejection. Here, the contract has been formed, but the offeree is stopped from enforcing the contract. Where acceptance follows rejection, mailbox rule does not apply, and the first one received by the offeror wins. The offeror need not read the communication for it to prevail. Acceptance by silence is generally not effective, even if the offer states silence qualifies as acceptance. There's one exception. This is based on prior dealings, where the parties have sufficient history of prior dealings. Silence may operate as acceptance. And again, notice of acceptance, it is required in a bilateral contract. It is only required in a unilateral contract where the offeror is unlikely to become aware the act is being performed, or if the offeror requests notice in the offer. And that concludes part 2 of contracts.